So you've no written contract and you're trying to figure out what happens with termination. The first thing to recognize is that contracts can arise in all sorts of ways. It's common for contracts to be written down, but it's not always the case. Contracts can be made by email, contracts can be made by text or by WhatsApp, and contracts can be made orally. All of those types of contracts can still be legally binding if they comply with the requirements for a contract under English law. So if you find yourself in a situation where you think that there is a binding contract, it's oral in nature, the first or the next thing rather that you need to check if you're thinking about terminating is, was there anything in that original agreement, even if it was oral, that dealt with termination? And if there was anything said about termination at the time the contract was made, then that will have to be complied with. If you proceed on the assumption that nothing was said about termination at the outset, then what you need to do if you want to get out of the contract is give reasonable notice. Now, what's reasonable will depend on context. It will depend on the length of the contract and the nature of the contract. In some cases, 3, 4, 5 days might be a reasonable notice, and in other types of arrangements and agreements, 6 months or even 12 months might be reasonable notice. If you don't want to give notice, or if you don't want the uncertainty of not knowing what reasonable notice actually is, then the next port of call is to try and terminate the contract by mutual consent. Approach the other party, tell them you want to get out of the agreement. It may be a matter of negotiation, it may be a matter of effectively buying your way out of the contract, but that's usually the simplest solution in circumstances where there's uncertainty, is to try and get both parties to come to some sort of an agreement. If you can't or don't want to give notice or don't want to wait to give notice, and if you can't get mutual agreement, well then the next type of situation is to see if you have grounds to get out of the contract. One of them may be that the other party has repudiated or abandoned the contract, in which case you might be allowed to terminate for breach. Another possible option is that the contract has been frustrated, or that circumstances have changed or something has happened, which now means that it's effectively impossible for you to continue to perform that agreement, and that may be a basis on which you can get out of the agreement. So when contracts aren't written down, it's tricky. When you're trying to terminate contracts that haven't been written down, it's also tricky. There are lots of different ways in which you may be able to get out of the agreement. What I would say is, if you find yourself in that situation, the best thing you can do is try and take advice from a specialist who has experience in contract formation and termination.